Over to you, sir.
society. All these things almost for 20 years I've handled it, right from registration, filing returns, getting exemption, addressing demands if they arise, resolution of disputes, all those things I've done. But what I find is that doing is different from speaking. Today we are required to speak on a subject which can be better done rather than spoken. It is like how to ride a cycle. You can teach any number of times, but unless you ride it, you will never get how to ride a cycle, like swimming. So you have to ride it. So this subject is also may look a little academic, that you are dealing about registration. What is there in a registration? But once you start doing the process, then you will understand there are certain nuances which we have to keep addressing. I will try to talk about the nuances today. Certainly, there is nothing to substitute the actual doing of a registration process. There are two registrations which are there in the context of a charitable trust. First is the mother law. When I say it's a society, we must register under Societies Act. When I say it's a company, we must register under Companies Act. Then comes the registration under the Income Tax Act for the purpose of exemption. Today we will first talk about the registration under mother law, and that possibly will help us to understand. Once we cross that, then the registration under the Income Tax Act comes as a secondary or subsequent step. What are the key issues which we will face? So we have to understand the governing law is not the same. If you look at the Charitable Provisions Act, it uses the words trust or it doesn't talk about society. It doesn't talk about anything specific. It doesn't talk about a company. But still, the words used are property held in trust, income earned from property held in trust. What is this trust? Whether it will cover a society, whether it will cover a company. The trust here is that somebody holds it in trust for the benefit of somebody else. And that somebody else which we are talking about is the general public at large. Your philanthropic trusts work on the basis that somebody holds it in trust, and there's a vehicle to hold that in trust, and the income is applied or the corpus is applied for the purpose of advancing philanthropic purpose. So the word institution or trust which is used, which will encompass everything. It will encompass a society, it will encompass a trust, it will encompass a Section 8 company or any other form of institution which you can think of. All of them are covered within the framework of trust or institution. So it's not necessary which choice of vehicle is required. Today we are talking about that. What is the scale? At the end of the session, possibly if I get 5 minutes, I will be able to say what choices we should make for which kind of activity. That should possibly help us to understand. As to today, somebody is in confusion. Many people, in fact, early in my day, people used to call me whether a Section 8 is better or a trust is better or a society is better, which one I should pursue. These kind of questions have emanated. We will try and answer this question at the end of the session and see whether we can get some thoughts on that. The governing law for a trust basically is the Indian Trust Act. You may not know, you may not even read, you may not even recite that it is recited, incorporated in the Indian Trust Act. Maybe there's a passing line which is mentioned, that is the Indian Trust Act which is governing the entire activity, but the governing law is the Indian Trust Act. Normally, if you look at a trust, there are certain constituents which are there. In a public charitable trust, the important constituent is the beneficiary will be general public. We'll come to that. The societies is covered under Societies Registration Act, which is a central or union act, but the states have a replica of the central act and they would have a state act. So you'll have Karnataka Societies Registration Act, Tamil Nadu Registration. So each state will have, so the Master Act is the Societies Registration Act. You will have the replica of the Master Act in the respect like stamp duty. You will find Stamp Duty Act and the State Stamp Duty Act more or less replicating that. So Societies Registration Act is the one which is the governing law. For Section 8 company, the governing law is the Companies Act 2013. So we must know the governing law. Why it is important? If you know the governing law, you will know what are the entire gamut of provisions that will apply to you under the governing law. Objects. A trust by incorporation is that I have a property. I don't want to use it for my benefit, I am the settler. I want to give to sir and say, sir, please hold this property on my behalf. Hold it, I am contributing to you. Let the income and the corpus be applied for the benefit of public at large. So there are three parts in this. A trust insert, there's a settler who is an author in the context of a trust act. The author says, I want to contribute the property. The trustee is the person in whom confidence is reposed by the settler, saying that you hold this trust property and apply it for the beneficiaries, for the benefit of the beneficiaries. So you find this is the construct of a trust, whether it's a private trust or a public charitable trust. The construct is there is a property, the property has to be sold. That is why in the Income Tax Act, income from property held in trust. That's the word which is used. That means there's a property held in trust, and the income arising from there has to be applied for charitable purposes. So that is the construct of the law. So there is a property that has to be contributed by somebody, and there is a trustee who receives the contribution, holds it in trust, applies it as per the direction of the trustee, the settler, who will be the part of the terms of the settlement of the trustee. In case of the society must have an objective which are literary, scientific, charitable nature, and the law itself will say, and other societies. What is other societies? Other society can be a building association, you are so on and so forth. So you have got many other things which are commonality of purposes there. They are not intended to make profit, but to defray kind of an activity. Then you will take a society kind of an activity. So most of the building societies are all registered as societies. They are not trusts, they are registered as societies. It may be easier to handle under society law because the incorporated entity, it has a legal recognition, and so on and so forth. The Section 8 company, the object is very clear. Section 8 itself makes it very abundantly clear. It says the promotion of commerce, art, science, sports, education, research, social welfare, religion, charity, protection of environment, or any such job. You will find all these words resonate with Section 2, subsection 15 of the Income Tax Act. You will find some kind of a parallel. They are all overlapping in the sense you can have substantial overlap. You will find that one is found in the other in some way or the other. Therefore, Section 8 company and Section 215 of the Income Tax Act, you will have some parity of thought. Similarly, you will find society also has an object which is more or less similar to Section 215. It may not be so much in detail, but nevertheless, it covers exactly what is covered in 215. So two vehicles readily qualify for being a charitable institution, both under the purpose of the mother law as well as for the purpose of Income Tax Act. Trust per se doesn't have any objective. It is for the settler to define what the objective he wants to do. It can be private objectives for private beneficiaries. It can be public objectives for public beneficiaries. So the object clause in a trust is not defined by the act, but is defined by the settler when he handovers the property to the trustee and says these are the objectives for which you should settle and apply the funds. So if it is philanthropic objectives, it will be a public charitable trust. If it is a private objectives, it will be private beneficiaries who will have. What is the constituent document? So automatically when you say you need a registration, you need a document. There are certain documents which are prescribed, so you need certain documents. What's the constituent document for the purpose of a trust? Trust deed should be in writing. Oral trusts are not acceptable in the process of any kind of activity here. In law, a oral trust is possible, but in these kind of activities, a oral trust is not possible. So it should be reduced to a document. Document itself means you must have the settler, you must have the trustee, you must have witnesses who have witnessed the kind of activity. You must have at least 2 witnesses to ensure that the document has been duly presented and signed as per the terms which are prescribed there. So based on this, you draft a document and present it. Typically, a document of a trust will have, number 1, who is the settler. Then it will talk who is the trustee. So it's actually a contract between the settler and the trustee. The settler says, I am giving this property, so there should be identity of the property. Normally, we will not put the entire property. We will say 10,000 rupees, 5,000 rupees, nominal sum. The trustee will hand it over the settlor will hand it over to the trustee and then say this is the purpose for which the trust is calculated. In this kind of philanthropic trust, there are two things which are important. The property is not complete. The initial 5,000 rupees may not be adequate to have all the activities which you want to perform. So what is required? The objective should say two things: ability to accept donations from the public and ability to accept donations either voluntarily for the not corpus donations or non-corpus donations. So one of the objectives you will essentially state in a public charitable trust is the ability to accept donation. So how do you fund it? What are the mechanisms of funding? If those objectives will have to be very clear. So one thing we have to see is that how do you fund the organization? How do you raise money for the organization? So you will say you will do. Second objective which you will say is that what can the investments be? After all, if I have raised money, I have held property in trust, it should be capable of being invested somewhere. So you will also talk about the nature of investments which can be done. A trust which is not seeking a 12AA registration can do any investment, should not be a problem. There are no limitations under the Act which cannot be done. But a trust which wants to pursue even Trust Act has some limitations, you can always get it over, because whatever is contained in the Trust Act, you can override that these clauses apply, these clauses don't apply, because it's a contract between the trustee and the settlor. You can try and overcome by trying to put a clause in. But once you want to register under the Income Tax Act, then it must comply with the requirements of investments mode in section 11(5) of the Income Tax Act. So the trust deed itself will say that the investment shall be made in modes as prescribed in section 11(5) or any other section which may be substituted in that behalf. So two things which should be very clearly stated is that ability to accept donations, ability to accept corpus donations as well as voluntary donations, ability to invest the money. That investment in the money should be for as per section 11(5) for philanthropic trust, otherwise your registration may not go through at all. Number two, non-philanthropic trust, or even if you don't want a section 12AB registration for a moment, then you can free yourself. You don't have to mention 11(5) also. You can carry on. There is nothing wrong. If a trust wants to pay taxes on its income and carry on its philanthropic activity, there's nothing wrong. You can carry on. There should not be limitation. Now, an important element comes to us. Assuming that I don't want a section 12AB registration at all. 11(5) investment itself means the yields may not be as much. Sometimes you may get a yield of 7%, you may get a yield of 8%. Somebody may say this yield is not adequate to meet because the trust activities, somebody will speak about it in the afternoon. 85% of the income you have to spend within the same financial year. If you don't do it, you have very restricted ability to carry forward in the year. With 8% yield on a corpus, on an income which you are going to earn, you may find that you are not able to adequately get adequate returns to defray your activity expenses. Some are administrative, some are in terms of how to perform your philanthropic work. Somebody may say, I am willing to get 12% yield on my investment. I am willing to pay almost 30% tax or 35% tax on that. My net income is still above 8 and not less than 8. Why I should get an exemption under section 12AB at all? Because if I am willing to pay tax on my trust income, then there is no need for a registration. So if you can free yourself from the investment obligation, then you may find that registration is not such a big driver. Actually, today you find many trusts are willing to surrender the registrations they are not able to do, because there are some complexities which have arisen because of cancellation of registrations which have other things come. Many companies, you can just go to the Google, you may find Tata Trust wanted to surrender the registration because they find the registration is a difficulty today rather than a privilege which was available earlier today. So if you make up your mind upfront that I will be a philanthropic trust, I will be a charitable trust, but I will not get 12AB registration, then 11(5) is not a limitation for you. If 11(5) is not a limitation, then you may get a little privileges which you otherwise you don't need. So assuming that a good accountant like us computes that I can earn 12-14% easily yield on my investment, I don't mind paying taxes on my income. Now I am left with net income, and that income I am willing to spend for whatever I want. You are a slightly free person. You may think. So just think whether 12AB registration is important at all for your client. You can create the structure for a 12AB registration. Don't go for registration immediately. Let the activities pick up. Let the donations come. Once you become big, maybe you want a registration at that point in time. Maybe you don't want it now. Think it over at what point you want a registration. Then memorandum, as far as society is concerned, memorandum is the key document. Both memorandum and the bylaws are registered. There's no problem. The memorandum is separated from the bylaws. There are two documents which are presented to the registrar. He will register. The memorandum has to be signed by at least 7 members. We'll talk about the members constituted a little later. So once the memorandum and the articles are presented, he will register. He will look at only the objectives, the registered office, because the registrar for society will depend on the office where you are located. There will be multiple registrar officers within the city of Bangalore if you want to take it. So wherever your office is located, the nearest registrar office you have to go and register. So jurisdiction-based registration. It's not central registration that you register anywhere and take care. So you have to go to that. So you have to find the memorandum and the normal memorandum. Very simple. You will state the objectives, incidental objects, and the rules will be how the members will be voting, how the governing body will be elected, and so on and so forth. That is how the entire construct will be: resignations, obligations, ability to sue, and so on and so forth, and the liquidation event, and so on and so forth. A memorandum of association in the case of Section 8 company is the memorandum of association and articles of association. If you look at the Schedule 1 to the Companies Act, you have got what's called the template of articles, what's called the tables under which the standard memorandum and articles are prescribed. As far as the Section 8 company is concerned, Table B and Table C are relevant for the purpose of memorandum of association. Table B says MOA of a company limited by guarantee and not having a share capital. Then Table C is MOA of a company limited by guarantee and having a share capital. So one is a limited by guarantee and not having a share capital. Another is limited by guarantee and having a share capital. We will try and solve the second riddle a little later. Yes, the mother law registration is required. Mother law registration. If you don't, I'll come to society. Company law, you don't have any problem but to register. Society need not be registered if you don't want, but you should be willing to accept unlimited liability. No. Collective instruments may come under SEBI. You have to do collective instrument vehicles. Yeah. Correct. Section 8 is possible. I would not. Collective collections vehicles are all partially covered under SEBI right now. You have to see under whether SEBI laws will be attracted for you. You have to look at. There are certain regulations which are covered under RBI and SEBI regulations as to who can raise money, collective collection scheme. So I would possibly say register under mother law. Society need not even register, but except you must accept unlimited liability, unlimited responsibility. That's it. So, but trust need not be registered. Trust has no mechanism for registration because there is no registrar of trust in most of the states. Some states have a registrar of trust. Such trust need not be registered. But company, Section 8 company, you have got no option but to register because recognition of the company arises only on registration. You have to get that. There are, I'll just clarify it. I don't have to repeat it since you have raised a question. Normally, you may not have a registrar for trust even in a state because there is no trust law under the state. States don't have a trust law. In Bombay, you got the Bombay Trust Act. In Rajasthan, you got the Rajasthan Trust Act. Those are all special charity governing trusts where you have to register. Most states may not have a charity like Bombay Trust Act. In other states, you register the document before the registrar or sub-registrar under the Registration Act. Under the registration. So the idea of that registration is that it creates a record on the public domain. It doesn't have any value. He is not a regulator. That registrar is not going to ask you questions whether your financial statements are done. It doesn't give you any protection other than chronology, that this trust was created on this day between these parties who acted. So the bona fides of the trust gets established, but you don't get the rights of any statute on that. So it's only a mere registration. Nobody can tomorrow question the document because it's part of the public domain. That's the only advantage. So you go to the registrar. Nowadays, all registrations, you have to visit the registrar. The settlor will go, the trustee will go. They have to sign the document in front of the sub-registrar, execute it. It's electronically executed. Your photo will be captured. It will be incorporated. Normal registration process, which you do in land registration, same office will also register the trust documents. It's not even the partnership registrar office, it's a separate registrar office. Okay, so normal sub-registrar office you go, you'll get it done. You can get it. Trust is always unlimited liability. Trust is always unlimited liability. There's no protection. We will talk about liabilities a little later. It has to constituent members in a trust. Settlor, I said, you need a settlor, one who will hand over the property. You need trustees, one who will receive the property and hold it in trust. You need property itself, otherwise you don't start the trust. Then who are the beneficiaries? In a private trust, you'll have private beneficiaries. In a public trust, general public at large. So you must say in your trust deed, who are your beneficiaries? Because trust is held for the beneficiaries. Who are your beneficiaries? So in a public trust, you can have classification. You will say people who are slum dwellers. No, it's a classification in itself. Slum dwellers. You can say promoting art, music, singing, everything. Beneficiary, public at large, but musicians who are competent. So promoting arts. So tomorrow if I have to sing, you have to find out I'm competent to receive any aid from you, whether based on. So I must, anybody singing is good, but you must see whether that's singing. So at what stage? These are all broad categories. The trustees and the settlor will have to understand how to apply it. If I can put it. So art, culture, they're all covered. It's not a problem. I will come to that. Trust, see, we have to understand each law in a different context. Trust, we understood earlier, there is no registration. The registration is only for record, for creating authenticity about it. Society has a registration, that's a governing law. Companies Act has a registration, that's a governing law. Trust doesn't have a governing law as it is an administrative law. Trust is an administrative law. So as far as societies are concerned, 7 members are required. So all societies are public trusts. 7 members, whenever you find 7 members as a requirement, they are all public trusts. You don't have private societies. They are all private, public societies if you get trust. Section 8 company, it can be either a private company or a public company. If it's a private company, you need to have 2 members at least. If it's a public company, you must have 7 members or more at least. That's how it works. So when a Section 8 company is registered with the objectives which are correct and the registrar pursues it, he grants a license to you, which is called Section 8 license. Normally, a company is identified with the name limited or private limited at the end. In a Section 8 company, the registrar will allow you to omit the words limited and private limited. So it will look like a foundation. It will look like a fund. So your name itself will not be suggested that you are a company. So many federations, you find Federation FICCI. I do not know whether it's a society or a Section 8 company, but you will find that FICCI, your trade associations, many of them are registered as Section 8 companies. The name will not carry the name limited or private limited. It will look like a trade organization or a commercial or a charitable organization. That's how the name itself will not make it very clear. That is a problem. Contents is very simple. Contents are all same everywhere. Let me say it is all the same how you construct it. The ingredients are the same. You will have name. There should be a name. There should be objects. There will be trustees. There will be there will be administrative step. There will be objects of activity. There will be objects of investments. where you will invest, and so on and so forth. You will have administration who will do the activities day to day, trustees being, or the managers being appointed remote. When I say managers, it can be directors, it can be trustees, or it can be governing body members. Each of them, how they will be appointed, how they will be removed, how soon the meetings will be conducted. So you separate the two parts. The objects are all contained in the memorandum. The name is contained in the memorandum. The rest of the things are contained in the articles of association. This is a normal format. One of the important events which is required in a trust is dissolution. Any document should talk about dissolution. What will happen in case it is dissolved in the event of extinguishment? So one of the important, so clauses will be all spread into, if you have these clauses, you must also talk about extinguishment, winding up, what will happen in those circumstances. We'll cover the winding up part. I've got some things to speak about it a little later. So this is how document will come. A typical document should have all these aspects: name, objects, parties, association, who are all coming together in the first place. When I say 7 members will form a society, so we 7 are forming a society. So who are the people who are forming that society? Then substituted members will all inherit the same society, because society will say by who are substituted as per the same constitution will also have the same powers as the original ones had. Likewise, you have some memorandum subscribers, article subscribers in a company. Likewise, in a trustee, you will have the trustee and the settlor coming through. They come together, agree on the document. Okay. Identity, name. Name is very important. Trust can have any name. There is no limitation. You can get a name. Society also can have any name. In a company, you need to have the name approval. You must see whether the name is available to you, seek an approval, then come back to it. So the approval process may be the limitation part of it. Society has not got that approval, pre-approval process so far. You can choose any name. It may sound similar to others. You may have litigation in that process, but nevertheless, you can choose a name. Trust also can have any name, should not be a problem. Distinctive trust, I will not talk about every aspect of it. Yeah, today our concentration is only on charitable activities, so we'll talk about only the charitable activity. A charitable activity trust is per se what's called a discretionary trust. Why it is discretionary? Because the class of beneficiaries are known, general public, but the actual beneficiaries are not known. You do not know how much money you will give it to whom. You understand that we will give the aid to the poor. So the class of people is those who are poor. But amongst the poor, who will get how much? Whether they will get this year or not, whether anybody will get it at or not, all these are functions of discretions of the trustee. So a discretion is vested with the trustee to distribute the money amongst the qualifying beneficiaries. Since there is a discretion, yet the trust is always a discretionary trust. In income tax, you will find that a discretionary trust, normally the assessment is done only in the hands of the trust, because you don't know the beneficiary. If you know the beneficiary in a specified trust, you will assess the beneficiaries. But in a discretionary trust, you will always assess the trust. Likewise, in a Section 11 trust, what is assessed is the trust. Beneficiaries are never assessed. And beneficiaries are always known to be general public. You may be asked to give the details of beneficiaries, how you have spent, where you have spent, all those are fine. That's application. But as far as assessment of the income tax assessment is concerned, it will be on the trust. And that's why you find that the entire activity is about the trust being assessed and not that the beneficiaries being assessed, because it's per se a discretionary trust. Societies Registration Act will say that the members don't have any interest in the assets. So members don't have interest in the assets. They are only trustees. They are only custodians. They have to apply it for the benefit of the trust. So the distinct feature in a society is that members all come together. They own the property of the trust. Trust owns the society owns the property. They only manage the property. They don't have any interest. So I have given some citations to take care of it. Section 8 company is also like that. Section 8 company has two important features, which is mandated by law, which is normally there even in a society, though not expressly stated. Yes, it must intend to apply its profits only for promoting its objects. So whatever profits are generated, income or profits are generated, that will be applied only for the objects of the trust, and no distribution shall be made to any of the members of the company. So two restrictions, very important restrictions. That means the members are all association only to discharge a trust obligation. That is, they are only discharging the objectives. They cannot benefit out of the trust. So these two obligations under Section 8 company are very important one. They have to be contained. Otherwise, you cannot register a Section 8 company. It is mandated by law. These two clauses, that the profits shall be applied only for the objects of the trust, and the profit shall not be distributed to the members. These are the very two important criteria which should be mandated in the memorandum as well as the articles. Yeah. Welcome. On conversions, registrants, welcome. How much time I got? Can somebody is keeping a time clock? How much time? 15 minutes more. So, it will be assessed as a AOA because trust assessment is a AOA. Trust law says that trust should be assessed as a AOA, maximum marginal rate. Correct. Trust is not an assessee. It will be trusted, trustee will, so it will be treated a maximum marginal rate. Correct. 45 minutes. I thought 15 was slightly, I thought, how do I compress myself? I was contemplating, I'll do it, but with some tricks other than. Registration Act, as I said, we don't have to deal more. Registration under the trust will be normally the Registration Act 1908. Some states like Bombay Charitable Trust Act, you have got Public Trust Act and Rajasthan Trust Act. Even Tamil Nadu tried to introduce a Public Trust Act that the bill was withdrawn later on. You may find more and more states sometimes enacting a trust law. Then you may have to register under that particular act. Even existing trust may be required at that point in time. So otherwise, the registration is done under the 1908 Registration Act. Society registration is not mandatory, but if you don't register, then your administration can become a problem because somebody can sue you, the members become vulnerable. It's like an unregistered association, and therefore ability to be sued, all those issues which are there for unregistered association, they will all flow. Section 8 has to be registered as a Section 8 company. We don't have an issue. Jurisdiction, normally trust doesn't have no trust. I have not seen many registrar of trust myself. We will wait for Falguna Kumar sir to see whether there is a registrar of trust other than the Bombay Public Trust Act, Rajasthan Trust Act. I have not seen a registrar of trust in any state so far, but knowledge can be very specific. Sometime your wider experience may find there is a registrar in some states. We may have to look at SEBI related. Mutual funds are all registered under SEBI because they are trusts. Many of them are trusts and they are all registered under SEBI. But we are not talking about those trusts today. But for clarity, many of the mutual funds are organized as trusts, and therefore it is a specified trust because you have got specific interest in each of the documents, and it will be covered under SEBI regulations. Society, normal under the central law, if there is a society, if the central government creates a society, then it will be under the Societies Registration Act. Normally, private societies, which you and I create, normally the registration will be done under the State Societies Registration Act. So Karnataka Societies Registration Act, Tamil Nadu Registration, and so on and so forth. Section 8 is a central government enactment, and the registrar is now competent to register. Earlier, the powers were vested with the RD. Now it has been delegated to the registrar himself. He can grant registration. Extent and scope, where all you can register. The trust can be registered anywhere in India other than Jammu and Kashmir and Andaman Islands. Society has to be whole of India, but if you look at the State Societies Registration Act, it may look at the state scope as the state as a limitation. Then you may have to have multiple societies if you have got multiple state activities. If you have to, for example, if you want to run a school, many states insist that you must form a society. They will not accept a trust. They will not accept even a Section 8 company. They will say you must form a trust in that state and then, society in that state and register. So schools are all governed by the state governments because education falls in the state domain, and they will be able to monitor. So they may insist on a society for a school. I'll have to learn again whether it's been given because the rules have not been notified. So 370 article has been removed. But what about the rules? Which will now travel? Which are the relays? What are the new rights which come? Tomorrow I want to acquire property in Jammu. I will not be able to do till the rules come. Okay. We have to wait for the rules. But anyway, conceptually I agree with you. The removal, whether it will cover. You can have an activity. It is about registration. You can have an activity in Jammu. That should not be a problem. No. If the purpose of the act, purpose of the trust is to protect the lives in Jammu, then you need an activity there. Applicability. Anything lawful can be done under trust. The Trust Act prohibits what is not lawful. Certain acts. So what is lawful, what is not lawful is a matter of common sense and a little deeper understanding of law. Normally, what is forbidden, not forbidden, you can do. So what is not forbidden, you can do. What is forbidden, you cannot do. So this is how the Trust Act is placed. That you should not do something which will defeat the provision of law. It's fraudulent per se. You create a trust for fraudulent purpose. Implies injury to persons and so on. So these are all placed in the Trust Act. Now, if the Trust Act is normally adopted even in an income tax framework, and therefore the trust we create for income tax purpose also will have these kind of implied meanings even if you don't. So you cannot create a charitable trust which aims to be charitable per se, but actually it's for fraudulent purposes. Those will all be covered both under the Trust Act violation as well as the income tax violation. Charitable societies, I'm not going into details. The member is very vast. It can cover a lot of objectives. There is no, whatever in 215 of the Income Tax Act, it will cover. Section 8 company can act as a Section 8 company only when a license is issued. Assuming that I don't want the license, I want to be incorporated like a guarantee company, you can. Law does not say you must get a license, except that if it is licensed, then your activities will be monitored like a Section 8 company. If it is not licensed, you can perform like a normal company, pay the taxes and so on and so forth. Nothing is wrong. Legal title to the property. The trustee is the legal owner of the property in a trust. He owns the property. And he has taken an obligation not for his benefit, but for the benefit of the beneficiaries. In a society, the legal title rests with the society. So you'll prepare a balance sheet. Even in a trust, when you prepare a balance sheet, we will prepare it. So only the income tax recognizes the trust itself as an entity. All other laws will recognize the trust as a vehicle. It will recognize only the trustee. Only the Income Tax Act, where the 12AA registration has been granted, recognizes the trust itself as an entity or institution which needs an assessment. So you find that when we prepare a balance sheet for a trust under the Income Tax Act, you can prepare it for the trust itself, but still it will be. But all other purposes, it's all only the trustee who owns the property. Even though the trust may reflect in its balance sheet, is the trustee who is the owner technically of the legal property. Settler. Settler has parted with. Settler owned it. He gives it to the trustee. I am the settler. I give the property. So settlement of the property. That's possible. Law does not prohibit. In my common understanding, there are 3 positions. 2 can be occupied one person. I don't know whether all the 3 can be occupied by one person. There's a settler, there's a trustee, there's a beneficiary. 2 can be occupied by one single person. All the 3 cannot be occupied by one single person. Apply the test whether it works well for you or not. Any 2 can be occupied by one person. Okay, you can be a beneficiary, you can be a trustee, but conflicts issues will emerge. You can be a settler, you can be a trustee. Okay, but you cannot be all the 3. Okay, so you take that. Yes. Society is a body, the legal body. It's recognized by laws. Like a company. It's like a company. Its legal identity is separate from the members. It will be sued in the name, can sue in the name. It is a legal body by itself. It's like a company. It has all the features of a company, except a society cannot be formed for commercial purpose. And number two, unlike a share, which can be transmitted from one person to another, which is the feature of a company, a society will not have transmission capability. You can appoint another member, but you cannot transmit anything in the sense. There is no property interest, if I had to put it. Still, what is that tell me. Possible. No, no, no. Then each one is a settler. Settlers. Take them all together. That's all. See, anybody who is an adult, competent to contract, all the parties in a trust, in any of these institutions, only a competent party can come and do this. That is competent to contract. So you have to see how the construct of the society is. It will all depend. Normally, my understanding is the society will not have ownership of any property which the residents own. There is a property which is the building proper. There is an undivided land which is apportioned to a particular owner. The society has only administrative capability. It will have ownership of assets like table, chair, fans, society buildings, and those assets it will own. It will not own the building. It will own only those assets which are required for administration. So if the society is so complicatedly formed that it has an interest in the land, it's the owner. It's the owner. Hmm. So members society as the title, company also the property vests with the title. Yeah, tell me. It's a revocable trust. A trust formed where the settler and the beneficiary are one and the same is a revocable trust. Mm. So the trustee is treated as a non-trust. In law, there is something, Trust Act, there is a possibility that you have not formed a trust at all, but you want to call yourself a trust. That kind of a situation will fall in. You may think that you are a trust, but actually you are not a trust. That's it. Property in law belongs to under the Indian law, different laws have different attributes. Under the Indian law, the legal title rests with the trustees. But they cannot sell and eat it themselves. They have to hold it for the benefit of the beneficiaries. So the legal title rests with the trustee. They don't own it. Beneficial title rests with the beneficiaries. India doesn't have a concept of beneficial title technically. So we talk about legal title. But the law, if you look at the Income Tax Act as well as the Trust Act, property held in trust for the beneficiaries. Okay. No. So what happens if you invest in a share? Assuming the investment in share is possible, you will hold it in the name of the trustee, because trust is not recognized by the corporate law as a legal person. So you will hold it in the name of the trustee. Okay. So anything which is a property will be held by the trustee. Bank accounts can be opened in the name of the trust itself. You don't have to open in the name of the trustee. My understanding, we have many experts. A bank account is what is got bank account will hold? It will hold cash balance, correct? Bank balance, which is nothing money. Money itself is not a property. So you don't ever need a title to that. So you can have a bank account which the trust can hold. But the moment it becomes a property, like a share, locker in a bank, or building, then they will all be held in the name of the trustee who is the beneficiary. He will say, I'm holding it in the capacity of a trustee. It will be, you just try. Tomorrow you want to open depository account, you trust in the name, They will say, well, the DP will say, I can't open it in your name. You try and register a property in the name of a trust. Maybe they will register it if they are ignorant, but still, don't worry about it. Registration may pass through. In law, the property is held by the trustee. Correct. In law, the property is held by the trustee. But if administratively, it may be held in the name of the trust. Don't worry. Those are all mechanics of the law. That is because income tax registered trusts are different from private trusts. Income tax registered trusts can own property according to them. They can do that. But not tomorrow if you want to, let me give you, if you want to own shares, assuming the share is not 11.5 is not permitted by, share is not permitted to be held beyond certain period. Even if you receive a share as a gift, you have to part with it in 1 year. Suppose you get a share. So you'll find, the income tax is an act which is based on ability to administer the trust. Some of the features of Trust Act are incorporated there. Some of the features of assessee proper is featured in the Income Tax Act. That's why you said the section 11 to 13 is a very unique provision. It may not have all the elements of a section normal trust, but it administers it in a peculiar way, you can say. That peculiar way is over a period of time patented, but nothing. That's why you'll find the trust itself is an assessee in the Income Tax Act, which is not normally a trust itself is not an assessee. It is only the trustee who is an assessee. Okay. It's okay. Liability in a charitable trust, status also may not be mentioned. They may not even say it's a public charitable trust and close it, if you can say. Liability, trustees have unlimited liability. You ask me. Correct. 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 Let me put it, to show the assets of gensets and all, we have to go into ownership, sir. That finally boils down to ownership. If you are saying I have given to society, all people have contributed the genset to the society to manage, I have no problem if you show in the balance sheet. Then it becomes, then it becomes the property of the society. It cannot be appropriated for the members. Correct. That's all. So it's it belongs to the society. Belongs to society. So you can be liberally employing people, spend more money. Stamp duty. We'll cover the stamp duty part in brief. Don't look at the slide. It's barely elaborate. 1,000 rupees is what is required for forming a trust under the Karnataka Act. You have to go to the state act, different state, more or less, it will all be parallel. Don't worry about it. Society, 200 rupees for the memorandum, 200 rupees for the articles or bylaws, as you say. Then you can. Under the Companies Act, Karnataka State Stamp Act, articles under a Section 8 company and memorandum are exempted. So there's no stamp duty for a Section 8 company under the Karnataka Stamp Act. If you transfer something which is more, 5% of the market value will be there. Okay. So just look at it. So first time, if you receive a property, normally, what you receive is money. Assuming that you receive some property or you part with some property, you will pay some stamp duty, and those are all subject to market value and 5% of that. Stamp duty, I'm not going too much into stamp duty issues. They are all covered. Essentially, you can take as a very nominal sum. Between the three institutions, Section 8 is the cheapest because you don't have any stamp duty. Society is the next cheapest because it's 200 plus 200. A trust takes about 1,000 rupees to register, but for that, the cost is not. Cost factor, a trust is minimal. You and I can sit in office, draft the trust deed. If you have some templates, we can complete it. The execution can be there. Go to the registrar, give the copy in advance. He will register it. If there are no many material illegal activities which are prescribed in the trust deed, he will go and register it. Society will take a little longer because you have to be legal about the drafting. There are clauses, there are memorandum and other things. Not as complicated as a company. Still a lot of freedom is there, but you can register it. MOA and AOA of a Section 8 company are fairly in detail. There are table, for example, I told you table B and C for memorandum and table G and H for articles of association. Those are standard tables, you can adopt them, but if you want some variations, you can do the variations part of it. FCRA registration, discretionary, not everybody is entitled. There's a 3-year track record or 5-year track record which is required. You may not get it in the environment in which we are there today. FCRA registration is quite a difficult one, but nevertheless, it is subject to meeting certain criteria. You will be able to get as a FCRA. Dissolution, as I told, is very important. Normally, any of these 3 documents, whether it's a trust or a society or a company, you must talk about dissolution. The power to dissolve should be one of the powers. And if you dissolve, what will happen with the residue property after settling all the liabilities and duties? This is an important clause we must have in what are the events for dissolution, what causes a dissolution. There is an illegality of activity in a trust or exhaustion of trust property, or the purpose for which the trust was created has been exhausted. That will all clear. Society also can be dissolved when 3/5 of the members decide that the society cannot be carried on anymore. It can dissolve. In a company, you can dissolve a company through a strike-off mechanism or through a normal winding up process, whichever is available today, and you can follow either of them. But upon dissolution, if there's a residue property, what do you do? A Section 8 company, normal private trust, if there's a residue property, it will go back to the author. In a normal private trust, whoever is the settler, if he's liable or his legal representatives, they will get it. So the author originally who contributed the money and the property, he will get the residue property because that's what the Trust Act provides. But under the Income Tax Act, it will not go back to the author. It will go to some other trust which has got similar objectives. So your trust deed must mention that upon dissolution, the residue assets after discharging liabilities and everything will be debts and obligations. Then it will be handed over to another society with similar objectives. That is what the trust deed must mention. If it is not mentioned, your trust deed will not be approved for 12AB also. Society law itself mandates that it will be handed over to some other society with similar objectives. Section 8 company also mandates that it will be handed over to another company or it will be amalgamated with another company with similar objectives. So you cannot hand over the property, it's dissolving. So it will be handed over to some other company with similar. So very, very clear that a property which is held for public charitable purpose, it cannot come back to the original owners in the form in which it came. Amalgamation, it can, yes, so a trust can amalgamate with another trust, but through a scheme. We may not know it, we may not have practiced it, but in law it's possible. One trust can amalgamate with another trust, provided there are parity of objectives, you can complete it. One society can amalgamate with another society. Law provides for that. One company can amalgamate with another. So Section 8 company can amalgamate with another Section 8 company. It cannot amalgamate with a non-Section 8 company. But converse is possible. A profitable company which is carrying on business and actual commercial activity can merge with a Section 8 company. A Section 8 company cannot merge with a commercial organization. That's how the law is placed. So a society can merge with another society. A trust can merge with another trust based on a scheme which you draw and present it as court. Court only can vary the objects of a trust when the settler is not there. And a Section 8 company can merge with another Section 8 company. Amalgamation, law itself mandates that if the trust is not, if the Section 8 is not carried on as per objectives and license, and it's found that the directors have violated the conditions of Section 8, the central government can direct that that company shall merge with another amalgamate. So amalgamate with another Section 8 company. So a merger can be voluntary based on the members' choices, or it can also be directed by the company, the central government, to merge with another Section 8 company whenever is required. When there is abuse of objects, the central government may mandate that you shall merge with another Section 8 company having similar objectives. Society, there is no direction that you must merge. It's based on you can. But assuming that residue property is there, you will say you will hand it over to another society which carries on similar property. All powers may be there. Law, I have not seen such powers, but maybe there are administrative powers we have to carry. Section 8 is very clear. There's a clear section which provides to that extent. I said, na profitable company, commercial organization can merge with a Section 8 company. There's a precedent I have cited. You can have a look at that. So a profitable company can merge with a Section 8 company. Should not be a problem because the profitable company will still continue to apply the profits for the purpose of objective. But it will fail the test of income tax because you are carrying on business for commercial purposes. So sometimes you have to think whether you want a 12AB registration at all. Defaults, trustee is responsible to the beneficiary. Any abuse of the trust objectives, the trustees are personally responsible to the beneficiaries. So that's the trust. The principle of trust, as we says, they are all emerging from the Trust Act. It's a breach of trust. If there's a breach of trust, the trustees are personally responsible to the beneficiaries. Likewise, the beneficiaries, if they misled the trustees and there's a loss which is caused, the beneficiaries are personally responsible to the trustees for the loss they create to the trustees. Section. Any member of public can challenge the trustee for abuse of objects, not being consistent with the objects. Possible. It's not. Any member can challenge it. It's not possible. That's why when you run many organizations, you may find, for example, I give you 5,000 rupees thinking that you are eligible man. You will say, I am equally eligible. Why would you not give it to me? Okay. So those dilemmas are there in any society. It's not fun. All public charitable institutions, you will have a dilemma which is not easy to handle. If there are litigations, you have to only say, we have not excluded you. This year I have selected him. You are still capable of getting received. You will not say you are not entitled. You are entitled, you are in similar position. This year I have chosen him because I have the discretion. Next year, whenever time permits, I will give it. You cannot say you will not get entitled, you are not part of the myself. That's not possible. Caste, creed, will, everything. Defaults, we will not talk of. Conversion. One trust can be converted into a society. Trust can be converted into a Section 8 company. So there's a conversion objective. What is that? How do I convert a non-company into a company? Section 366 of the Companies Act deals with conversions. How a non-company can be converted into a company. So you will have to follow a table A and table C. Or so you have to incorporate everything. So a trust which is in the nature of association can be converted into a company. A society which is always an association by nature can be converted into a company. So you can go and tell the registrar, please convert me into a company, put the necessary forms, he will convert you. Section 8 company cannot be converted into a society. Section 8 company cannot be converted back into an association. Once it's Section 8, it can amalgamate, it can liquidate, it can wind up. So you have to see which side, which flow will have it. Charitable purpose, not very important here. I wanted to say the objects of a society and a company are similar to 215. You may compare it. Exact words may not be there. Scope is more or less similar. Some twisting may be there from here and there. Then any trust or institution, I said, any trust or institution here means holding in trust doesn't mean there should be a trust. It can be a society, it can be a Section 8 company, it can be a board, it can be anything. But holding in trust, it means I'm the trustee, I'm holding it for the benefit of the public at large. Society, no problem, sir. You go in. Today, we are flooded with information. To the registry, nothing is difficult to get it. You go through internet, you get the format. Every day you get it. You have to only size the objectives, whether we will have something with 2 words. That's all. Today, 2 days, societies can be registered. No problem. 2 days you can register. Today you form the deeds. Tomorrow morning you make an appointment with the registrar. Make 7 members present themselves, it will be registered. 200 rupees challan, no problem. Hmm. Hmm. Sir, even if you say I own something, whether you actually own something is the law has to prove now. I own Vidhan Sauda, I can say, doesn't mean I own. Non-discrimination, a public charitable trust, once again, I'll cover this, it cannot be based on caste, creed, color, religion, gender, sexual orientation, disability, political ideology, all these should not be the matter of discrimination. So this word, this sentence, if it is not there in your document, it will not be registered for 12AB. So this sentence, if it is not captured for a moment, you omit it. You presume that your registration granted will also be sometimes come for review, it may be liable to cancel. So you must say it will be carried without caste, creed, etc. I am talking about public charitable trust. Religious trust will have all this. There will be caste, there will be creed, everything will be there. Religious trusts fall in a different category altogether. But public charitable trust cannot have any of these characteristics. So you have to say caste, creed, color will not be there. A religious trust, to the best of my knowledge, may not be getting a 80G benefit. A public charitable trust can allow a 80G benefit. So, registration under the income tax 12AB, every 5-year renewal and so on and so forth. Somebody is talking a little later about audit reports and all. I will not go into that. Essentially, registration has become complicated. So it is not no more a lifetime registration. You have to keep on renewing. This regime used to be there earlier, but not in the same form. So every 5 years, you have to demonstrate your activity, you are continuing. Cancellation has very deep implications of a registration. So what property you will own in the trust, all those things will have to be determined very soon. For example, if the registration is cancelled, then the accreted value becomes taxable. What is accreted value? Suppose I purchase that, settle the trust in 1950. At that time, I contributed land which was only 1 lakh. I purchased the land. Today, the trust owns the land and is worth, say, 1,000 crores. If the trust registration is cancelled, that accreted value of 999 crores or whatever is that, that becomes taxable to you. So accreted value will become taxable to you the moment the registration is cancelled. So we must be very careful that a 12-day registration is maintained if you have certain property which have very increased value which has come over a period of time. Withdrawal, cancellation, all these have the same effect. So it's become today, at the point when the law change happened, if you are not surrender your registration, you are sitting on a huge piece of land, you have a problem. The best way to handle the problem, according to me, is that sell the land, pay the capital gains tax, and contain the accreted income to the levels because you have anyway sold it. That's one way of doing it, if you can say. Which conversion? Then there's no problem. Accreted comes only for registered trust. Yes, sir. If you not register under 12AB, it will not come. That's the problem. Not for the previous years. Register from the time registration is active only. Registration is always prospective. There is no deemed registration. There is no deemed registration under the law. You apply, it comes in the same financial year. You are well and good. Sometimes they may give it retroactive, but not. It is not retroactive. It is always. So from the date you apply only, you will get it. Correct. 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 So property already registered in the name of the trust deed. Trustee. Trust, no problem, sir. Hold it. Nothing. In law, it's held by the trustee. Okay, that's all. on the building. See? Land is to be given back. You can own. You can own, continue to own. How do you own a building without a land on which you don't have a right? So two things you have to do. One, a minimum subsistence lease license you must continue to have on the land. Otherwise, you must have an arrangement that the building, even though you are owning, there are two kinds of ones, a permission to use a particular land, other is a lease. If you get a permission, according to me, saying that you can continue to own the land, you can continue to operate, but it's not a lease. But you will have some GST issues. You must handle the GST issues also. So otherwise, you have to sell the building to the landowner. Otherwise, demolish the building, scrap, and so on and so forth. So the best part in this kind of arrangement is very common arrangement. What you say is very common. Land owned by somebody, building owned by the trust is a very common arrangement people make. You have to continue the lease from time to time. Which one? 3 years. Every 5 years the renewal now. So they will make it permanent for 3 years. After that, 5 years. After that, 5 years. Well, so all these are temporary measures. They are also not equipped to handle this change in law. Suddenly you find all registrations have come. They will also find it difficult to administer the law as to how you are complied and all. So last point was, go ahead. I have to think and come back. I don't want to give you an answer which is just off the cuff. Because can there be a building on a land where you don't have a right? This is what is the fundamental. It is like the UP bulldozer case. You are having a building on a land which you don't have a right. Okay, what happens? This I have to possibly understand. I don't have an answer. If the next expert is going to speak, if he has an answer, I will possibly look forward to his guidance on that. I don't have a ready answer. These are complicated arrangements you create with the idea because you don't want the land rights to be taken away by the government. So you don't want to put it in charity trust. Correct? This is the underlying thought. I'm being frank with you, it's not that. So you don't want the land to be touched, you don't mind the building to be demolished also. Technically, that's the principle on which it will come, sir. Based on your performance, you are. Correct. After. Over a period of time, you file your returns and all, you'll get it. No problem. Yeah, CSR activity. All the three are qualified to receive CSR. No problem. A trust can receive a CSR. Section 8 can receive a CSR. Society can receive. There's no problem. But if it is a CSR created by the company which is making the CSR, then it should have a 12AA registration and ATG recognition. Both should be there. Likewise, in a CSR which has got a 3-year track record, both are required. Government formed societies, government formed trusts don't need any registration. 12A is not required. No problem. It's not covered. That's the real. There are very people who don't qualify. I have to think it over. Now the parity of provisions is there. 1023C and 11 are more or less made pari materia. In the sense, there is a parallel. The amendments are all making it almost, whether you have a 1023C or 11, both are the same. Maybe you can look for 11 application and surrender 1023C. That goes. They will merge over a period of sir, over a period of time, there have been divergence in the two sections. Now they have brought some parity between the two sections. With some experience, you will further bring private parity. Then they may abandon one of them and say, please merge it with. Then you will have 1021, another one, which is surviving, which will possibly look at it. Over a period of time, they will get merged. We also suggest to the government that two sections have parallel activities, parallel law. You merge. Today, I don't know exact differences which will there, But somebody who is very seasoned with both 1023C as well as 11 will tell you that this is a small difference which is there. If this is made up in the law, both can be merged. Then you will get it. You have to tell the government for either tell the Ministry of Corporate Affairs that 1023C, see madam, education is abused. So 1023C, most of them deal with educational institutions. So there is an apprehension in the government, you will not very easily get it. But Section 11 also, many trusts are carrying education, it's not a problem. So in fact, how do I transfer if I am a member in a society? I say I will retire as a member, I am the management. I and sir are continuing as a member, 7 members are constituted. Tomorrow is a large educational institution, medical college, everything is run under a society for a moment. I will resign as a member, I will collect the money, because finally it's a business which is going on there. I'll collect as memory from you, because you are the substituted members who are coming in. What will be the nature of the income? Because you are not getting any benefit out of the property which is held by the society. But what you are getting is the advantage of a membership in that society. Okay, so right, being a member, that's a property right. So you have to understand every trustee or a member has 2 positions in law. One of a trustee, which is the office related position. The other is a property related position. A position can be property related or a position can be office related. If you sell the right to somebody else because the bylaws allow you to do that for whatever reason, that will be property related right, and there will be certain tax consequences which will have on that. But you have not touched the asset. Asset is still in the society. What you have sold is the membership right. Correct? To the members. Settlement of salary in kind is possible, but you will pay capital gains tax unless you are exempt. See, you have to file the return as if you have sold the property to guideline value will apply, 50C will apply, all those things will apply. You will report capital gains, but you applied for charitable purpose because you have disbursed this. It is barter. That's in a way it's a barter. Because teachers are all employees, you won't have a GST problem. That's the problem. Otherwise, you will have a GST problem also. So nowadays, sir, I can tell you very honestly, sir did make an introduction. Most complex subject in the income tax today, combined with GST law, combined with other regulations which are there, is actually the charitable provisions. If somebody has learned charitable provisions in the Income Tax Act very well, I can say he will understand all other provisions easily. The most complex subject today is charitable trust. You touch it, there's a problem. I am struggling with many promoter group. I am just giving an example. Many of the share, I am part of Mr. Azim Premji Foundation full. The entire corpus, how it has been sold, it may be worth, maybe 2 lakh worth crores of properties are being held at charity. All those are fine. I have never created a 12AB trust because I don't want the obligations of a 12AB trust. I'm willing to run without a 12AB. I'll pay the taxes, if I can say. Okay, that's one. So you find out the scale at which you want. What should I choose? Very long pan-India operations, and you want to hold large of assets in the company. Company is a very formal organization. There will be minutes will be recorded, board meetings will be held, AGM will be held, upload of financial statements will happen. Formal organization, if you want, which is capable of being administered by you through active secretarial practices, choose a sectional company. Some organization that you will at least file the annual report with the registrar, take a society. I am very lacking in skill. I am not too very competent. I can only file the income tax return. Nothing else I can do. Choose a trust. So the scale will determine what kind of an organization you choose. Trust for very small operations where you and your family are doing family objectives you are doing. Scale is not the issue. Take a trust. Society where you need a little more rights, statutory rights to sue, to so on, property, everything. And it will be wider where others also get involved. Then society. large-scale operations, pan-India, global, go for Section 8. Registration under 12AB, choose only you have to. If you don't want, don't choose. If you can pay taxes on your income and apply the income for different purposes, don't worry. Don't take registration, because 12% minus 30% tax or 35% tax may work out to be better. Today, a Section 8 company can opt for 25% tax. Under law, it provides you to allow 25%, assuming that you are willing to pay 25% tax on your income. So if you earn 12% yield on your investment, your net income is 8. Correct? 25% taken away. With 8 rupees, that's what you will get in a 11.5 investment for a moment. Think whether you need a registration at all. Okay? Why follow every complex law which has so many threats against you? Think whether you need it. Inspection will be there. Any charity, public charitable institution, inspection. Say anything you touch public, government intervention is there. You cannot say I'll serve the public and not be subject to government regulation. You will be there. So either through the registrar of companies or to the registrar of societies or through some other mechanism. So the government regulation we are not avoiding. We are avoiding complications of the Income Tax Act. That's all. Nothing more. We are not. No. Nothing. Intervention is always there. Such large corpus we cannot say. And finally, we are doing activities which are permissible under law. That's not the thing. So I'm saying it's not to. Government interventions, regulations are welcome. Exemption causes a little amount of limitations for me. Exemptions mean I have to narrow down to 11.5 investment. 11.5 investments are not the best. I hold shares of Wipro in my trust. 11.5 does not allow share to be held in the trust. Okay. So those limitations. Many promoters, they all want to do it. Okay. So all these things are performed. Everything has, no, not with registrar. With income tax, yes. That's why you construct the trust. If there's an endowment act, you have to file a return there. That's why I'm saying. Yeah. So if there's an endowment act in a state which requires you to give the construct has to be very solid, sir. You don't do large scale charity activities without a proper structure in that. We do it. No, CSR is chosen by the board. Board says I like slum dwellers. But your Section 8 of your company may have a lot more objectives. So how to drive your project into CSR? The board will have a review. There's a CSR committee which will say how the project money has been spent and so on. So it's a box within the box. That kind of makes sense. Provided 3 conditions. If the company has settled the trust immediately, but it must have a 12AA registration and ATG exemption. Likewise, any other trust, third-party trust, 3 years existence, track record. Section 8? Yeah, that's all. Well, that's all. Part of the regulations will keep on changing. You enroll it. They will monitor you for your fund, how you are making it. You have to keep separate accounts sometime for the money spent, not spent. Those are all CSR regulations. Which one? CSR money you can receive, sir. That's why the 85% under the Income Tax Act will have to be kept in mind. Whether you have to spend 85% of the income under 5 minutes you are giving me, you are fine. Corpus and non-corpus. Corpus can be any amount, no problem. But nowadays corpus, you have to give it as a corpus with the instruction of the donor, etc. There's no problem. So they can anytime, but not the core. You cannot remove the no caste creed. You cannot see the objectives will be for perfume for India. You cannot say that 11.5 investments can be removed. All those you cannot amend in a 12AB registered trust. Name you can also alter, no problem. But subject to your trustee regulation. Trustee should allow you to change it. So trustee says this name shall not be changed by anybody. Bad luck. These are all, any change in the memorandum or articles will require registrar's name. But you have the necessary resolutions passed, present it to the authority. Change. For example, even in a Section 8 company, you can change the name. But change of name, we have to follow the process which is prescribed under regulations. But I'm not saying it's not a prohibited activity. You can go and change it. That's it. In a trust, in a company, what do? Both sides you have to do. Because you have to say the name availability, new name availability, test it with the company registrar, go to the commissioner, get an approval. That's it. I think very engaging a session. Lot more questions will come. This is a session I could have left it a little open to have more questions and less of discussion. But essentially, you can presume that this gives an idea about registration, what to choose, whether to choose, all those. I will touch upon only those aspects and a little legality as to who owns the property, who is the, nothing more. It will be related. See, those who are contributing substantial donation is treated as a related party in the concept of Section 11. So any benefit you give to them in turn will all be monitored under Section 13, whether it's a reasonable price, all those arm's length test. Number one, trustee itself is a related party. Is also a donor, will make him another related party. So you have to consider that. Okay. So I would have loved to do a lot more justice to this subject. It's a free subject. We can have, actually sir was very right in this morning. This subject should be discussed with forms, which column, what do you feel, what is the thing. It's a workshop kind of a mechanism. It will work well. We must, and that also will show cross experience. I would have ticked the form in a particular way. You may have a different idea. Say, sir, I don't agree with you. This is a form. That will generate some moment of conversation and discussion amongst us. And possibly we'll leave some other occasion, we'll do it for the institute. And thank you.
I thank CA P.V. Srinivasan sir for enriching us with the details of all the registration related to trust, society and Section 8 companies. Thank you, sir. I'd request CA Tuppan sir to hand over a token of appreciation from our end. We would break for tea now and assemble back at 12 for the next session.